Welcome to episode 13. This is a discussion of Chapter 13 of UAE Crypto Litigation, available at www.uaecryptolitigation.com.
Thank you. It is great to be here to unpack this one.
So I want you to imagine wiring a significant sum of money in USDT to a business contact. And you do this based on a handshake, a couple phone calls, and maybe, a vague WhatsApp message.
Oh, yeah, highly informal.
Exactly. And in your mind, you are buying equity. You are funding a joint venture and securing your position as a partner. But then, say 2 years later, that business is booming, but your counterparty claims that the crypto you sent was just a loan repayment.
Or maybe just compensation for an isolated trade.
Right. So you have zero equity and you have absolutely no paperwork to prove your original intent. And that brings us to the nightmare of unwritten agreements in commercial digital asset transactions.
Yeah, and it is a scenario that plays out, well, far more often than you might think. And the core issue here is really the fundamental gap between on-chain reality and commercial reality. I mean, a blockchain ledger is exceptional at proving that a specific wallet sent a specific token to another wallet. Right, at a very specific timestamp.
Right, it tracks the movement perfectly.
Exactly. But what the blockchain cannot prove is why that token moved. It lacks the intent.
And that intent is exactly what we are focusing on for this deep dive. Our mission today is to explore how UAE courts handle the burden of proof when these highly ambiguous financial disputes actually hit the docket.
Yes, and we will be moving from the reactive reality of litigation to the proactive strategies of regulatory compliance.
Right, looking at how current virtual asset regulations actively prevent these evidentiary voids. And finally, we will break down how commercial parties can design their own contract so that their legal framework perfectly mirrors the mechanics of the blockchain itself.
So we are essentially tracing the evolution of risk management here. We start by looking at what happens when commercial parties operate entirely without structure. And we end by examining the highly engineered transactional architecture that's required to survive in a mature digital economy.
Absolutely. And to ground this in reality, we have a determinative 2024 judgment from the Dubai Court of First Instance. And just as a quick reminder, you can find more details on this case and a copy of the book UAE Crypto Litigation at www.uaecryptolitigation.com.
Perfect. So looking at the factual dispute here, we have a plaintiff who transferred a substantial amount of funds across multiple dates.
Right. And these transfers were bifurcated,
Yeah.
right? Directed to two distinct recipients. There was an individual defendant and a corporate defendant.
Exactly. And that bifurcation is, well, it's the first critical piece of the puzzle. The architecture of the payments themselves begins to tell a story before anyone even testifies.
But the plaintiff's narrative attempts to sort of unify those payments. He claims all of this money was sent based on an oral agreement. According to him, the individual defendant convinced him to become a partner in the corporate defendant's business, which operated in the freight shipping industry.
Right, a classic joint venture pitch, allegedly.
Yeah. So he asserts that he sent these substantial funds specifically to buy a partnership stake. But when no partnership materialized, he filed a lawsuit demanding the return of all the money based on a breach of this unwritten agreement.
Which is really a classic claim of unjust enrichment and breach of an implied contract. I mean, the plaintiff is essentially arguing that the underlying consideration for the transfer completely failed.
But the defendants present a completely fractured reality from that. I mean, they deny the partnership narrative entirely.
Oh, absolutely. They argue that the funds sent to the individual defendant were specifically for digital currency trading.
Yeah.
Exchanging USDT to fiat and vice versa. Oh. And for the funds sent to the corporate defendant, they argue that money was payment for shipping raw materials from China.
Okay, let's unpack this. Because if you are sitting on the bench as a judge, you have bank records showing money moving, sure, but you have two diametrically opposed stories about the intent. If it's literally just the plaintiff's word against the defendant's word, how does a civil court even begin to untangle an evidentiary knot like that?
Well, it requires a very strict adherence to foundational legal mechanics. The court does not just weigh the two stories and pick the one that sounds slightly more plausible.
Right. That's not how the system works.
Exactly. Instead, in this 2024 judgment, the Dubai Court of First Instance anchored its entire approach in the UAE civil transactions law.
Starting with the definition of a contract itself, right?
Yes, exactly. They started with Article 125, which provides the statutory definition of a contract. In civil law jurisdictions, a contract requires a definitive meeting of an offer and acceptance that results in a mutual obligation. And from there, They move to Article 243, which is the principle of performance. That principle dictates that contracting parties must actually fulfill what the contract requires.
Yeah.
But to mandate performance, the court first needs objective proof that the specific obligation existed in the first place.
So who carries the weight of proving that obligation? Because if I'm the plaintiff, my instinct is to say, look at the ledger. I sent them a massive amount of value. Make them prove why they're allowed to keep it.
Well, that instinct would lead to a dismissed case.
Oh, really?
Yes.
Yeah.
The court applied the fundamental legal maxim of the law of evidence, which states that it is incumbent upon the creditor to prove the debt and upon the debtor to prove its discharge.
Incumbent upon the creditor, meaning the burden rests squarely, heavily on the plaintiff.
Entirely. The court established that a mere transfer of funds is, well, it's legally neutral. Proving that funds moved does not automatically shift the burden to the recipient to justify keeping those funds.
Wow. Okay.
Yeah, so the plaintiff, who is claiming he is owed a partnership stake or a refund, he must definitively prove the specific contractual intent behind the transfer. And since he relied purely on an oral agreement, he had an extraordinarily steep hill to climb.
Which brings us to the procedural turning point, I think, because the plaintiff obviously couldn't produce a signed contract. So how does a UAE court resolve an impasse where the documentary evidence is effectively zero?
Well, the court exercises its inherent authority to appoint a specialized financial expert. This is a very distinctive and highly robust feature of UAE civil procedure.
So they don't just rely on the lawyers arguing.
No, not at all. The judge deploys an independent technical expert to conduct a forensic audit of the commercial reality.
And what does that actually look like in a case involving digital assets and, international freight? Are they just looking at basic bank statements?
Well, it is far more forensic than that. The court-appointed expert's mandate is to trace the actual application of the funds. They examine the operational reality of the defendants. So in this case, the expert verified that the individual defendant did, in fact, operate a digital currency account. Specifically, it was a trust wallet. And they engaged in digital currency exchange. So they mapped the plaintiff's payments to the individual against the mechanics of those specific crypto transactions.
So they established a commercial mechanism that perfectly matched the defendant's narrative for that first set of payments.
Correct. And they applied the exact same rigorous tracing to the corporate defendant. The expert audited the company's operational records and confirmed it was actively engaged in sea freight and cargo transport.
So the story lines up.
Perfectly.
Mm-hmm.
They found that the funds transferred to the corporate entity corresponded directly with a specific shipping operation for raw materials imported from China.
That's incredible. The expert essentially rebuilt the paper trail that the parties completely failed to create themselves. They found that the money was exchanged for actual quantifiable services, not for some speculative equity stake.
Yes. The expert's report systematically validated the defendant's bifurcated narrative. The ultimate conclusion submitted to the court was that these funds were consideration for specific services rendered crypto exchange and freight shipping and entirely unrelated to any commercial partnership.
Now, if I am the plaintiff and I see this independent forensic report completely dismantling my entire lawsuit, my next move is panic. I mean, I'm going to petition the court to let me bring in witnesses. I'd want to drag in anyone who was at the coffee shop when we supposedly discussed the partnership.
Yeah.
How did the court handle the plaintiff's attempt to introduce oral testimony at this late stage?
Well, the plaintiff did exactly that. He filed an objection and desperately requested the court refer the case for investigation just to hear witness testimony.
Good.
And what's fascinating here is the court rejected the request outright.
Outright. That seems definitive. Why wouldn't the judge at least hear what the witnesses had to say before ruling?
Because it speaks to the strict hierarchy of evidence in UAE civil and commercial procedure. The court adopted the expert's report in its entirety and issued a final judgment dismissing the case. By doing so, the judiciary reinforced a really profound reality. Comprehensive documentary and technical evidence of commercial activity fundamentally trumps belated, unsubstantiated oral testimony.
That makes total sense.
Right. If an independent expert can map financial flows to concrete commercial operations using ledgers, wallets, and shipping manifests, the court will not entertain witness testimony intended to retroactively conjure a different reality. The objective data rendered the subjective human memory moot.
That is a stark warning. If you do not document the purpose of your transactions and the counterparty can point to a credible, documented alternative explanation for why they received the funds, your unwritten claim will just collapse under the weight of the burden of proof. Now, this case study revolves around an incredibly informal, unstructured arrangement. It's basically the Wild West of handshake deals. But if you look at the digital asset landscape in the UAE today, it has evolved into one of the most sophisticated regulatory environments in the world.
It really has.
So what does this all mean for regulated businesses operating in the UAE today? If this exact factual scenario happened today, but the defendants were a licensed virtual asset service provider, a VASP, how does the current regulatory matrix alter this dynamic? Could an evidentiary void like this even exist?
Well, if the entity were a regulated VASP today, this level of ambiguity would be a structural impossibility.
Really?
Impossible. Yes. The regulatory frameworks enforced by the Securities and Commodities Authority, the SCA at the federal level, and the Virtual Assets Regulatory Authority, VAREA in Dubai, are explicitly designed to eradicate the very informality that caused this lawsuit.
Okay, let's expand on an analogy to really visualize this for the listener. Engaging in the unstructured deal we just discussed is kind of like doing a handshake agreement in a dimly lit room where no one takes notes. But the VARA and SCA regulations effectively force everyone to conduct their business inside a brightly lit bank with security cameras recording every serial number.
That is a great way to look at it. And I would take that analogy a step further to explain the actual mechanics. The VIRA transparency regulations act as the bank's security cameras, recording every serial number and timestamp. But the asset segregation rules act as the safety deposit boxes.
Okay.
You cannot accidentally mix your personal cash with the bank manager's cash because you literally do not share the same vault space. The regulations replace trust with prescriptive, mandatory architecture.
Let's unpack those specific regulations that act as those cameras and deposit boxes. Where does the framework actually start?
It starts with the absolute mandate for written agreements under the VAR Market Conduct Rulebook. But it goes far beyond standard boilerplate contracts. Rule 2B1K is the critical mechanism here.
And what does that rule mandate?
It requires that client agreements must explicitly identify if and when any assets, whether fiat or virtual, will not be owned by the client at any time.
Oh, wow. That is fascinating. It forces the parties to establish a binary definition of ownership right at the inception of the relationship.
Exactly. It instantly neutralizes the whole partnership versus service fee debate. If a regulated VASP accepts a transfer, the mandatory contract must dictate whether those assets remain the property of the client, held in custody, or whether ownership transfers to the VASP as a payment for a service.
You can't just change your mind later.
No, you cannot wait 2 years and suddenly claim a fee was actually an equity investment. The mandatory regulatory contract has already locked in the legal reality.
But, a contract is just a piece of paper. How do the regulators ensure the technological systems actually reflect what the contract says?
Well, that is where the technical standards come in, specifically SCA Annex 7/2023, which governs virtual asset wallets. VASPs are required to implement robust systems that mitigate the risks of misuse.
And mechanically, what does that require?
Mechanically, this means integrating sophisticated API gateways and blockchain forensic tools that determine the exact source of virtual assets for every incoming transaction and the exact destination for every outgoing transaction.
So the VASP's technological infrastructure has to automatically flag the provenance and purpose of a token the second it hits the mempool. There's no such thing as a mysterious deposit anymore.
Precisely. And this is fortified by the asset segregation mandates in the VAI or custody rulebook. A VASP must keep a client's virtual assets in segregated wallets containing only that client's assets.
Right.
Commingling operational funds like the VASP's own money with client funds is strictly forbidden.
And the practical application of that is immense. Because if our plaintiff tried to claim he was investing in the VASP's corporate operations, a simple audit of the wallet architecture would disprove it instantly.
Instantaneously, yes.
If the funds went into a segregated client custody wallet, it's not an equity investment. If it went into an operational wallet, it would have to be logged as a fee for service, according to that Rule 2B1K disclosure we talked about.
The evidentiary record is baked into the code itself. Furthermore, SCA regulations mandate detailed continuous reporting. A custodian must provide clients with monthly statements clarifying all trades, transfers, and balances.
So you have a constant paper trail.
Exactly. If you receive 12 consecutive monthly statements showing your funds being utilized for crypto exchange services, you cannot credibly file a lawsuit in month 13 claiming those funds were intended for a freight shipping partnership. The continuous reporting prevents disputes from incubating in silence.
That makes total sense. And what about the individual defendant in our case study, the person acting as a broker to exchange USDT for fiat?
Well, under current SCA regulations, if that individual were deemed a financial influencer, they would be ensnared in a web of strict disclosure requirements. They are legally compelled to disclose any direct or indirect material compensation. Again, the regulatory mechanism forces transparency and destroys the viability of secret, undocumented financial relationships.
It is incredibly clear that the UAE regulatory framework operates as an automated defense system against these types of disputes.
It really does.
But regulations only govern licensed VASPs. If you are an institutional investor, a proprietary trading firm, or even just two sophisticated commercial parties putting together a digital asset deal, how do you proactively build these protections into your own private bilateral agreements? How do you avoid ending up in the Dubai court of first instance?
The author provides a blueprint for this, and it requires shifting your mindset from just legal drafting to full transactional architecture. In the digital asset space, your legal contract must perfectly mirror the operational mechanics of the blockchain.
Here's where it gets really interesting.
Yes. The author frames this as creating legal code matching smart code.
I love that framing. So a PDF contract shouldn't just be a list of promises. It needs to be an operational flowchart. What is the first foundational block of this architecture?
The first layer is the principal-to-principal disclaimer. You must contractually sever any implied relationships before the transaction occurs.
Okay, severing implied relationships.
Right. The agreement explicitly represents that both parties are acting strictly at arm's length, for instance, engaging solely in proprietary trading, and it formally disclaims any fiduciary duties, joint enterprise, or partnership.
So you are proactively neutralizing the exact argument the plaintiff made in our case study. You write, essentially, under no circumstances are we partners.
Exactly. It isolates the transaction. The next structural requirement is the segregated application of funds. This is where the legal text dictates the blockchain mechanics.
And how do you draft that, practically?
You contractually forbid the commingling of obligations. If you have an agreement that encompasses multiple services, say crypto trading and software development, the contract will mandate that payments for the trading must be routed to wallet A, and payments for the development must be wired to bank account B.
Ah, so you force a one-to-one correspondence between the legal intent and the on-chain routing.
Exactly. And you include specific language stating that a payment routed to wallet A can never be applied by the receiving party to satisfy an obligation for bank account B. The routing itself becomes the objective proof of the payment's purpose. Every transfer of value is structurally self-documenting.
That completely eliminates the ambiguity of the overarching lump sum transfer we saw in the court case. But what about the timing of the transactions? Because, crypto moves fast, but settlement can be disputed.
That is addressed through strict settlement windows and confirmation protocols. You do not draft a clause that simply says the buyer will transfer the funds. Way too vague. You draft a protocol specifying that legal delivery is only deemed complete and the obligation discharged once the transaction achieves a specific, mathematically verifiable number of block confirmations on the required blockchain network.
So you are tying the legal definition of performance to the objective, immutable state of the blockchain. A judge doesn't have to weigh testimony about whether a payment was received. They literally just look at the block explorer.
It creates a frictionless, objective standard for performance. And the final, most crucial piece of this architecture is the entire agreement clause.
Right. But if you are listening to this and thinking, well, I always use a standard NDA and a basic token purchase agreement with an entire agreement clause, so I'm safe. Does that standard boilerplate actually hold up when millions of dirhams are on the line?
Well, in the UAE jurisdiction, a meticulously drafted entire agreement clause is not just boilerplate. It is an absolute legal firewall. This clause formally dictates that the written contract, alongside its designated schedules and hard-coded wallet addresses, constitutes the sole understanding between the parties.
So it isolates the document.
Yes. Critically, it explicitly supersedes and cancels any prior written or oral agreements, representations, or negotiations.
So if a party attempts to introduce a WhatsApp message or claims there was a secret phone call altering the terms of the deal, the entire agreement clause completely blocks that evidence from altering the contractual reality.
If we connect this to the bigger picture, it acts as an impenetrable barrier. A judge reviewing the contract will recognize that sophisticated commercial parties intentionally elected to be governed solely by the mechanical, segregated protocols contained within the four corners of the document.
It turns chaotic human relationships into matters of objective contractual certainty. This has been a dense but deeply necessary exploration of commercial reality. Let's summarize the core takeaways for you listening. First, relying on unwritten agreements in the digital asset space is an existential risk. In UAE civil procedure, the burden of proof is unforgiving. If you claim an obligation exists, you alone must prove it. Second, when factual disputes arise, the judiciary relies heavily on forensic, court-appointed experts to trace the commercial reality, and comprehensive technical evidence will systematically defeat belated oral claims. Finally, true security requires either operating within the strict transparency frameworks of regulators like VAR and SCA, or engineering your own mathematically precise transactional architecture, where your legal clauses perfectly mirror your on-chain mechanics.
The overarching lesson is that intention must be codified. However, looking ahead, and drawing directly on the author's insights at the end of Chapter 13, it is important to note that while this specific judgment demonstrated the formal difficulty of substantiating an unwritten agreement, the absence of a signed contract is not automatically fatal in every circumstance.
Oh, wow. That is an intriguing pivot. When would an informal agreement actually survive judicial scrutiny?
Where the terms of an informal agreement can be definitively substantiated through alternative forms of objective evidence, particularly comprehensive digital communications, and the demonstrable sustained conduct of the parties, the courts have shown a willingness to construct and enforce those obligations. Next time, in Chapter 14, we will explore a direct contrast to today's case. We will analyze a scenario where the UAE courts actually did construct and enforce an informal crypto asset investment mandate, relying purely on the forensic trail of digital transaction records and messaging logs.
That brings us to the end of our discussion on Chapter 13. This chapter's structure is the standard methodology used throughout the book.
Authored by Mahmoud Abu Wasil, and drawing on analysis from over 100 judgments, UAE Crypto Litigation serves as an indispensable resource for those in the digital asset industry.
To read the full analysis for this chapter, and to explore the complete 7-part life cycle of a commercial dispute covered in the book, please visit www.uaecryptolitigation.com.
The discussion in this podcast is for educational and informational purposes only, and does not constitute professional advice or any other professional relationship. Please consult with a qualified professional for advice tailored to your specific situation.